And now we come to the fourth clause, the last clause of the definition of murder under section 300. Culpable homicide is murder if the person committing the act knows that it is so imminently dangerous that it must in all probability cause death or such bodily injury as is likely to cause death. And coupled with this knowledge, there is another fact. The fact is that the person commits such act without any excuse for incurring the risk of causing death or such injury as aforesaid. So, to fall in clause 4.3 of section 300, the offender must have the knowledge that his act is imminently dangerous, and he also should have no excuse for incurring that risk. If he has an excuse, then he will not fall in clause 4.3. This illustration appended to section 300 will explain the position more clearly. A, without any excuse, fires a loaded cannon into a crowd of persons and kills one of them. He has no excuse, and even then, he fires a loaded cannon into a crowd of persons and kills one of them. Now, here he has a knowledge that his act is imminently dangerous, and therefore A is guilty of murder, although he had no premeditated design to kill any particular individual. He had no intention to kill any particular person. He had even no intention to cause bodily injury to any person. But he had the knowledge that his act was imminently dangerous and he had no excuse for incurring that risk. We shall analyze the provisions of this clause also with the help of a Supreme Court judgment. The judgment says that clause 4 of section 300 would be applicable where knowledge of the offender as to the probability of death of a person or persons in general, as distinguished from a particular person or persons, being caused from his imminently dangerous act, approximates to a practical certainty in all probability. Such knowledge on the part of the offender must be of the highest degree of probability. The act having been committed by the offender without any excuse for incurring the risk of causing death or such injury as aforesaid. The source of this analysis is the Supreme Court judgment in the case of State of Andhra Pradesh versus Rayavara Pupunaya. Now we shall see the correspondence between the three clauses of section 299 with the four clauses of section 300. Clause A of section 299 corresponds directly with clause 1 of section 300. In both these clauses, the intention is to cause death. Wherever there is intention to cause death, it is the offense of murder. Clause B of section 299 corresponds with two clauses of section 300, clause 2 and clause 3. Because in both these clauses, the one requirement is intention to cause bodily injury. Along with that requirement, there is one more requirement in both these clauses. That requirement is different in each of these clauses. The difference between clause B of section 299 and clause 3 of section 300 is one of the degree of probability of death resulting from the intended bodily injury. The word likely in clause B of section 299 conveys the sense of probable as distinguished from a mere possibility. The words bodily injury sufficient in the ordinary course of nature to cause death, which appear in clause C or clause 3 of section 299, mean that death will be the most probable result of the injury having regard to the ordinary course of nature. And then lastly, clause C of section 299 corresponds with clause 4 of section 300. In both these clauses, the requirement is that of knowledge of the offender. Both require knowledge of the probability of the act causing death. There are 5 exceptions to the offense of murder specified under Section 300. Each of these exceptions takes away a case from the offense of murder and makes it a case of culpable homicide not amounting to murder. Here is the first exception. Culpable homicide is not murder if the offender causes death while he is deprived of his power of self-control, and this deprivation of his power of self-control is on account of grave and sudden provocation given by the person whose death he has caused. This exception is also available where the offender causes death of any other person by mistake or accident while he continues to be deprived of his power of self-control. Let us now see what are the essential ingredients of this exception. So the question is, what are the essential ingredients? And here is the answer. There are 6 essential ingredients. The first is, the deceased must have given provocation to the accused. The person whose death has been caused must have given provocation to the accused, and this provocation must be grave and it must also be sudden. The provocation must be grave and sudden. The offender, by reason of this provocation, must have been deprived of his power of self-control. He must have lost his power of self-control. And causing of the death should have happened while the offender was deprived of the power of self-control. The offender must have caused the death of the person who gave the provocation or that of any other person by mistake or accident. If the death is caused of the person who gave the provocation, then it can be intentional. But if it was of some other person, then exception 1 will be applicable only if the death was caused by mistake or accident. It cannot be intentional. This is the next question we need to answer. What is the test of grave and sudden provocation? The most important ingredient of exception 1 is that there must be grave and sudden provocation given to the offender. So what is the test of grave and sudden provocation? The answer is, the test of grave and sudden provocation is whether a reasonable man belonging to the same class of society as the accused, placed in the situation in which the accused was placed, would be so provoked as to lose his self-control. Whether a reasonable man would lose his self-control under the same circumstances. That is the test. Thus, it is the test of a reasonable man, and the test is whether a reasonable person placed in the same position as the accused was would have reacted to the provocation in the same manner in which the accused did. If a particular offender overreacts to a provocation, then this exception will not be applicable. Is there any uniform standard of reasonableness? The answer is no. What a reasonable man will do in the given circumstances depends upon the customs, manners, way of life, traditional values, etc. In short, the cultural, social and emotional background of the society to which an accused belongs. The reasonable man should belong to the same cultural, social and emotional background of the society to which the accused belongs. Whether words and gestures alone, unaccompanied by acts, may also cause grave and sudden provocation. That is, whether grave and sudden provocation can be given by words and gestures alone without there being any accompanying acts. And the answer is yes. In India, words and gestures may also, under certain circumstances, cause grave and sudden provocation to an accused so as to bring his act within the first exception to section 300. Can the mental background created by the previous act of the victim be taken into consideration? Victim is the person who gave the grave and sudden provocation. The question is whether the mental background created by the previous act of this person can also be taken into consideration for finding out whether this provocation which he finally gave was sufficient to deprive the offender of his power of self-control. The answer is yes. The mental background created by the previous act may be taken into consideration in ascertaining whether the subsequent act could cause grave and sudden provocation sufficient for committing the offense. And the last question now. What is the effect of time lag between the act of provocation and the commission of offense? The answer is the fatal blow should be clearly traced to the influence of passion arising from that provocation. The blow which caused the death of the person who gave the provocation should be clearly traced to the influence of passion which arose from that provocation and not after the passion had cooled down by lapse of time or otherwise. When a grave and sudden provocation is given to a person, it will not last forever, and with time its effect will vanish, the passion will cool down. Once the passion cools down, thereafter the benefit of exception 1 will not be applicable. Because if the passion has cooled down, then it gives room and scope for premeditation and calculation.